Hey there, everyone. This is Ryan Smith, principal and founder of ThinkSBA. Welcome to another episode of the My SBA Loan Pro podcast, Face to Face. I have with me today attorney Scott Oliver, who is a partner with Lewis Kappes. They provide lender side closing legal advice for SBA lenders. Scott, thank you so much for being on the podcast.
Thanks for having me, Ryan. I really appreciate it.
So, what I'd like to do is kick this off by giving us a brief background, including your education, maybe other firms you worked for, and how you arrived at representing SBA lenders during the closing process.
Yeah, certainly. I mean, there is a long version and a short version. I will try to keep it as short as possible. So you said background education. I'm actually a graduate of Purdue University in West Lafayette, Indiana. I ended up going to law school at IU, which, if you know anything about Purdue and IU, they kind of butt heads a little bit. But when I went to Purdue, I knew that I wanted to be an attorney, and I knew I wanted to be in the closing context in some shape or form. So I was always really interested in mergers and acquisitions and the business side of things. Going into law school, I was like, well, maybe not. Maybe I want to be in the courtroom. I very, very quickly figured out that that was not the place for me. After working at a couple of large litigation firms, I decided that no, it is business. It is what I want to do. So I ended up taking what's called a summer associate position at Lewis Kappes. So the trajectory and the history of my firm experience is actually pretty much at Lewis Kappes, because I ended up landing here, going through all of the different departments that we have at this firm and landing squarely within the SBA legal department. Because I met with my mentor. His name's Chris Poling, who's been doing SBA lending for 25, 30 or so years. And he said, look, you like business? Do you like small business? Do you have a passion for this? Well, look what I do and why this is so important for our economy and why I think that your skills will fit. And the moment that I did that and I started opening up files and reviewing what the SBA programs were all about, I fell in love with it. Which, if you're in SBA, you can probably relate to that. But outside of SBA, my wife looks at me and says, what the heck are you doing? This doesn't make any sense. But for me, it's fun, it's exciting, it's interesting, and we really are doing good work for America's entrepreneurs. So I've been in it ever since.
Absolutely. And what I love about people like you, Scott, and when I say people like you, I mean people who knew what they wanted to do and who they wanted to be from an early age. I jokingly say that I still don't know what I want to be, but you were so focused on being an attorney, and then you quickly determined that being a litigator was not for you, and that you'd rather practice more on the transactional side. And then you settled in the SBA legal department. And what you said is absolutely correct, almost to a person or anyone who lasts in the SBA field. They do have a passion and love for the entrepreneur, for the business owner, for America, for the economy. And that is something obviously that shines through not only in this podcast, but what you post on X, your family, etc. And so what I'd like you to do now is define for the audience what you do during the closing process for SBA lenders.
Yeah. So, in short, we do virtually everything. And I know that's incredibly broad, but in a nutshell, it starts when a deal is committed. So, when our clients have a commitment letter signed by the borrower, they have what's called a commitment letter and then a credit write up. Your audience is probably very familiar with the credit write up, but it's usually a pretty long document that tells you all of the nuts and bolts about the borrower, about the deal structure, about the requirements, etc. So our primary clients will engage us at that point when they have that letter. We then prepare an internal checklist of sorts. I actually call it a DLP. That's a long story that we don't need to get into, but it's an internal checklist that tracks the entire transaction from start to finish. So when we get engaged, we're working directly with the closer mostly. The closer to work with the borrower, borrower's attorney, sometimes seller's attorney, title company, escrow company, broker, what have you. No deal is the exact same, as you know, but there are a variety of different parties, and we're essentially quarterbacking that entire closing process for most of our clients. So there is a heavy legal component to that for SBA eligibility, contract review, title insurance negotiations, landlord waivers, all of that fun stuff. But we're also there as just that communication tool to make sure that you're closing, quickly, but also in compliance with the SBA guarantee, in compliance with all of the ever-changing rules that I'm sure we will get into to make sure that yes, the borrower gets his or her funds, but if something does go sideways, the bank is fully protected. And that's kind of our stamp of approval on each and every transaction that, hey, you did this properly. The borrower did get their funds. Everybody's happy. But you also have a very, very good airtight loan so that if something happens in the future, you, bank, are protected.
And that's something that a lot of borrowers don't understand is that the SBA guarantees the loan proceeds to the lender. But if the lender doesn't follow their policies and procedures, dot every I, cross every T, during an audit, the SBA can say, we are not going to guarantee this loan, or we're only going to guarantee up to this portion. And so I think what you're saying is that your role is to ensure, as legal counsel, as an advisor to this SBA lender, that what they have done will pass muster during an audit.
Yes, and a lot of times when we're working with buy side counsel or buyers or whoever it is in the transaction, we tell them that up front. I like to say that, hey, if you can close an SBA deal, you can close any type of deal. And by the time that you get done with the SBA closing process, yeah, it can be a little bit difficult and a little bit daunting because there are a lot of requirements. But the moment that your deal crosses that finish line, your business is in no better shape than it could ever possibly be. I mean, it is in the best shape that it can possibly be because of these stringent requirements that the SBA has. None of them are unreasonable, but they're all to protect the borrower so that the borrower is successful and can repay that note that is guaranteed by the government.
Got it. So you mentioned the landlord waiver. Can you talk a little bit about that document? Share with us maybe a few instances where the landlord has unintentionally maybe cost the borrower a lot of money with redlining back and forth.
Yes, of course. Those come up, almost daily. The landlord waiver is a document that is required whenever there is a business location being leased by the borrower. Okay. And that document, as long as it's sent to the landlord very early on in the process and counsel or the bank is involved early in the process, it's usually negotiable. Some of those terms that are in there are aspects that you do need for an SBA closing transaction, but they can be, moved up and moved down to make sure that everybody's on the same page. If you get that early, we can get in there very quickly and explain this is a document for X, Y, and Z. You're signing it because of this, and here's why it's required. A lot of times, just that conversation, that phone call rather than email, is eye opening for a landlord. And if a landlord has an attorney involved, we can point to statutory provisions, we can point to the SOP, we can say things that show the attorney that this is just part of the game that we're playing, and it's not necessarily or ever really against the landlord's interests to be able to sign that document. But it's all about communication at the end of the day.
Yeah, I think that's a great point that you brought up. And I'm excited and happy that you shared that so that my audience, when they watch this or listen to this, can grasp this and convey this to their landlord. Since we're landing right now on you representing the lender, what I'd like to do is have you share with us what makes a bad buy side attorney, or an attorney who possibly could put a good transaction in jeopardy if they don't act the right way.
Yeah, there's really two extremes here. So if you have buy side counsel who represented your brother's best friend 20 years ago in a divorce and is just doing this M&A transaction because he or she is cheap, the legal fees aren't there, and they've never seen it before, that is the recipe for a disaster. Because when I'm working with them and giving them SBA requirements, or the buyer and seller counsels themselves are negotiating, they're throwing everything against the wall and hoping something sticks. And at that point, I'm seeing things in these contracts that could adversely impact the borrower, that are ineligible for SBA financing. And then when we have that conversation that normally works out really well, where we just explain to them logically and lawyer to lawyer what's going on, they put up a wall and they get defensive. when in fact it's just us trying to protect the borrower and our client at the same realm. So an inexperienced M&A counsel can be an absolute nightmare. Now, on the exact opposite side there, a highly, highly, highly competent counsel
I know
usually,
where you're going.
yes,
Yeah, I know where
usually
you're
can
going with
be
this.
found, billing anywhere between $1,200 to $2,000 an hour. They're incredibly competent and have done plenty of deals, but most of the deals that they're doing are hundreds of millions, if not billions of dollars. And closing an SBA transaction is very, very different than closing a multi-billion-dollar transaction at, insert firm name here. They will sometimes be so incredibly rigid and unwilling to budge or unwilling to understand that the SBA program is different, that they put up a wall and end up killing the deal over something that's completely unnecessary. So, what we really like to see in these transactions are attorneys who focus in small to medium sized business work, or attorneys, even better, that focus in small to medium sized business work and know about SBA transactions. They might not be SBA attorneys like myself or any member of our team, but they at least understand the gist of what has to happen and why. Those people tend to be very effective.
Got it. Let me ask you this question. There are things you do every single day, every transaction, right? It's just repetitive. What are some rare circumstances, scenarios, or requests that have been made by buy side counsel that you've worked on that either was acceptable to your law firm and the SBA, or possibly unacceptable, and you had to go back and explain why this is unacceptable, why they need to drop this request immediately?
Yeah, I think there's a distinction that needs to be drawn between getting creative and being ineligible, right? So I will have deals frequently where maybe we have to have some sort of escrow holdback at closing of seller's proceeds, right? Or maybe we have to do something with a seller's lien that protects the bank, and all of those things amount to us taking a stance that gets the job done, but is a little bit untraditional. That's usually okay, so long as the bank is 100% protected and we are following SBA guidelines to a T. Where we get into eligibility issues is if I have buy side counsel who comes in and says, "Oh, at SBA Form 155, one, I've never heard of that, and two, I'm never going to be able to get the seller to sign this document because I cannot agree to one, two, three, four, five. We need to revise it." Well, no, you can't. There are some bright line rules within SBA that if you can't play in that sandbox, you have to get out. And that's why I always tell those types of attorneys, or if I feel like it's, well, really any transaction, get that stuff out into the open as early as possible so that we don't run into that, stone wall 72 hours before closing. If we have a seller's attorney or a buyer's attorney that's going to be unreasonable, I want to know that right up front so I can say, look, we can't do that. And that's fine. We can't do that. But we want to know that on day 2, not day 32. Okay? It's a little bit of a different situation.
And what I heard you just say there, and this is important, so I just want to share with everybody the obvious. I'm not an attorney. The lenders, meaning the business development officers I work with, are not attorneys. The underwriters are not attorneys. The loan committee, they are not attorneys. Here's the however. However, buyers, work with professionals who specialize in SBA financing because they will help you prepare the package in a way that is eligible and acceptable so that when it gets to Scott, he doesn't have to unwind the transaction and possibly jeopardize it because your buy side attorney took control, or your landlord, that will be your future landlord, took control and mixed everything up and confused everyone and made it ineligible. So it's very important because by the time it gets to Scott, he's going to review everything, make sure, like he said, the bank is protected. And if you're working with an inexperienced bank, maybe an inexperienced broker, business development officer, et cetera, and they don't understand the SBA, they could approve an ineligible application that ultimately cannot close. And the reason I wanted to share that, Scott, is there obviously are a lot of individuals out there now who are pretending, you might say, to be SBA experts. They're not. And I'm sure you see that where you have something on your desk that's just not going to work. And that brings me to my next question. We actually had an interaction on X several months ago in regard to SBA loan docs. From time to time, I have clients whose counsel will ask to review the SBA loan documents. And based on the criteria that you shared, either they're extremely inexperienced or they're extremely experienced, they may not understand the presentation of the SBA loan documents, and they may begin to redline them like they were a fourth grade English teacher and plop those back on your desk. And so I just want you to give clarity to the buyers out there who ultimately will be sitting at a desk signing these, or maybe on their phone or computer now. How flexible are these SBA loan documents? Have there been instances where an attorney has made reasonable red lines that you have accepted on behalf of a lender? Share that with us.
Yeah, so most of the SBA loan documents themselves are not negotiable. I know that sounds like a hard line stance, but I try to take that with the attorneys, day one that I have that conversation. I'll say, look, this is an SBA loan. I've done conventional loans, okay? And I've done conventional loans where we redline the crap out of those. We redline and we negotiate until, the sun goes down. SBA is not that. All right. And as long as they know that up front, I have no issue sending the draft package to buy side attorney. In fact, I prefer it because it's nice for a buy side lawyer to be able to look at the documents, sit down with their client and say, okay, you're signing this is what it means. You're signing this is what it means. All of those types of conversations are arguably a very good thing. Time is money for most buyers, yes, so consider that. But that is a net positive. When I get anything back from buy side counsel, if it's like your third grade or fourth grade English teacher that you mentioned, uh, that's a non-starter for me. I'm not doing that. That is not something that needs to be done. We can go through each of the questions and have dialogue and have a conversation about it. And I will bring it to the lender, but SBA boilerplate is SBA boilerplate. There are other documents within the loan package that may have a little bit of flexibility, but I don't see it, if ever, in those situations.
Got it. Thank you for providing that clarity. And what I'd like to do now is transition to some recent changes that the SBA has made to the standard operating procedure manual. You mentioned the ever changing rules, and 2023 proved to be a monumental year for the SBA and the SOP specifically. There were sweeping changes that were made, and I'd like to get your opinion on those changes and if you believe those changes will benefit small business owners, entrepreneurs, et cetera, going into the future, and or if maybe at the same time there is cause for concern or pause in these changes.
I think it's a little bit of both. All right. On the pro side, I think most of the changes, allowing partial ownership changes, stating, that forgivable seller notes under certain situations can be done. Those types of changes open the box for more entrepreneurs or types of entrepreneurs that want to go out on their own. Right. And we've seen that. We've actually seen quite a few of those partial ownership changes, which to me means, hey, there might be some people out there who previously were not able to get an SBA loan who now can get an SBA loan and they can pursue their dreams. That's really, really good. And that flexibility is great. The negative, I think, is more for my clients. It's more for the banks and the lenders because they're dealing with rules that were put out in late 2023 that still to this day, some of them remain a little bit untested. And you have lenders who will go out and they are, either risk averse or they're willing to take a little bit more risk. When they're taking those types of risk, I have to counsel through them and say, here's what you're doing. Here's what the SBA SOP says. Here's what historical context says. Here's what we're hearing from the SBA. These are the risks and the benefits. And some of them are saying, we'll go for it. We think that this is okay. And will it be? I hope so, and it should be, but it's still very much untested. And my concern is that we get 5 years down the road, and the SBA looks at something and says, "Well, that was a gray area of the SOP, and you did this, and shame on you, slap your wrist." We haven't seen it yet, and some of those types of rules are a little bit unclear. And it kind of goes to your point where you said you are seeing people who are holding themselves out as SBA experts out there who maybe just started an SBA or just trying to interpret rules a specific way and getting very creative with their deal structures. The SBA does not like creative in most circumstances. They like black and white, they like their rules. So I'm seeing so many different structure types that are like nothing that you've seen before the new SOP came out. And sometimes they don't fit squarely within the rules or the box. And we'll have to say, well, we have to explore this a little bit. Maybe we have to send a GP. Maybe we have to have dialogue with key people to figure out if this is indeed eligible. And most of the time, that works out for the better because we figure out that, hey, it is eligible and we can do this now where we couldn't before. But at the end of the day, any sort of vagueness like that makes me a little bit nervous.
And so you had mentioned at the beginning of this episode that you get involved after the commitment letter is signed. And so I just want to walk through that process for the audience. Maybe they have never applied and they're getting ready to. So the general process is a borrower will fill out an application. Their loan application will be underwritten. It will either be approved by the underwriter or in some cases loan committee. And then if the loan application is approved, then the lender will issue the commitment letter. And the commitment letter, as it sounds like, is a commitment from the lender to lend. And then also when the borrower signs it, it's a commitment from the borrower to follow through on the transaction. And so the lender will start spending money. Now I want to ask you this question based on what you just said. So what you're telling me is that you are seeing loans go all the way through the pipeline, get to you with what you've called creative loan structures that make you pause and have to then give advice to that lender on whether or not what they've presented will be acceptable in a future audit.
Yes, that's correct. And in other instances, the loan structure changes and it has to be approved by the lender. We'll get deals in sometimes where they say, "Hey, we are going to do an X dollar acquisition as an asset purchase." We get a commitment for an asset purchase, and then 3 weeks go by, and their accountant came into play and says, "Oh, that's not such a good idea. Let's do this as a stock transaction." Well, a stock transaction is very much different than an asset transaction, and if they want to do that, the borrower wants to do that, it then has to go back to loan committee. It has to be reapproved with that specific structure. And when they do that, frequently they start trying to get creative. And if they start trying to get creative with that structuring, it's on us to kind of look at that and say, look, well, this is why this doesn't fit. You're trying to put a square peg through a round hole, bank. And while at the end of the day, the bank can make business decisions to proceed or not to proceed, our whole role is to really be that GPS. You've probably seen or heard me say that before. The GPS to them to say, in light of everything that's going on, here are the regulatory considerations, here are the legal considerations, and here is how we recommend that you proceed. If they want to take that risk, that's completely fine. We're not here to blow up deals by any means, but we are here, and we have seen virtually any transaction structure you can imagine to provide you with legal counsel to make the right decision about how to structure your deal or how to get the closing to the closing table.
And can you just give a definition of GP for the listener, for the watcher?
Of course, GP general processing. So certain banks are GP lenders, others are what are called PLP lenders. The GP lenders do have to submit the loan to the SBA for approval, whereas PLP lenders can actually make certain decisions on their own without involving the SBA.
Got it. And I just want to reiterate, based on what Scott has said, that is why I choose to work with individuals inside the SBA ecosystem who know what they're doing. And if you're a buyer out there and you've gone to a lender on your own and everything seems very easy, no questions, no, I don't think you can do that. And everything just keeps going and going and going and going. And then all of a sudden it gets to Scott or someone like him and the deal comes to a screeching halt, you know you've worked with an individual, maybe a lender who doesn't really understand the process. They don't understand what's at stake for their bank. And unfortunately, Scott, you know this, that happens. And what happens at that point in time is that lenders go out of business. And there have been many lenders who have just stopped lending here within the past few months, years. And if you're in SBA long enough, you'll see lenders come and go. And there's usually, and this isn't necessarily a good thing, but it happens, there's usually the it bank, right? the bank that's doing everything. And that gives me a little pause because I'm thinking to myself, what does this really mean for the buyer? What does this mean for the future of that lending institution? And are they making sound decisions? Because at the end of the day, I consider myself someone who's a gatekeeper, meaning that the loan has to get through me before it gets to the business development officer, the underwriter or committee, and then ultimately to you. And I just like to speak to buyers. Buyers, you want to work with individuals who know SBA, who work with people like Scott, and who are gatekeepers who are going to shepherd your loan in a way that, again, as Scott has mentioned, protects you as the buyer and means that you're going to have a successful transaction. And then, ultimately, what we're all here for, Scott, right, is to set up the buyer to be successful, to operate, own the business, put food on their table, put their kids through college, fuel the American economy, and live that happy life that we all desire here in the United States. So I really appreciate you sharing all of this information with us, Scott. And I want to ask you now, because one of the major changes, and you mentioned it, but one of the major changes in 2023 was the institution of partial change of ownership. And I used to get those calls. Hey, Ryan, can we do this? And it was just absolutely not. The SBA doesn't allow it. I think this is the most major change that happened in 2023. Can you tell us how that's changed your practice? Do you think this has been as monumental change as it seemed at the time?
I don't think it is as monumental of a change as people thought it was in the first week. Right? In the first week, I would see, post content after podcast after podcast where people saying, "Oh, we can do this. It's open the floodgates. Everybody gets a loan," right? And fortunately, you were not one of those people. That's a good thing. Uh, that is not the case because while it did allow for partial changes of ownership to happen, those partial changes of ownership are very specific scenarios following very specific rules. But the good news is people are figuring out how to use those rules and make them work in their transaction, right? So now what I'm seeing when deals hit my desk, they're structured more often than not appropriately within the spirit and within the rules of the SOP, which is really, really good to see. When I think of a partial change of ownership, I'm usually thinking of a situation where there's maybe an owner who's getting along in age and maybe wants to retire, but doesn't quite want to retire all the way. Maybe wants to retain that 5% ownership and say, hey, I don't have to be a guarantor, right? Unless I'm a key employee of some sort and critical to the deal. I want to sell this 20 or 30 or 40 something year old my interest and really give them to the keys of the castle, but I still want to keep that 5%. All right. Before, absolutely not. Could never do that. It is ineligible, case in point, right? After the changes came out, those people who wanted to do that now have a way to do that. And that 5% owner, right, who is the seller on the transaction, can remain as more than just a consultant, right? Because that's another piece of the partial changes of ownership. If it's a complete change, seller can only remain as a consultant for a period not to exceed 12 months, including extensions. All right. If it's a partial change of ownership, as John or Jane who just sold their interest and wants to hold on 5%, they can remain and they can remain in different capacities. They don't exit the business entirely, and you still have an eligible transaction that allowed that younger person or that whatever that person is the ability to step up and become a true owner and a controlling party within that business. And I think that's really cool to be able to see that happening.
And I want to ask you this. What do you think? And again, this is not legal advice, everyone. I'm just asking Scott what he thinks. And I have my own opinion on this, but what do you think is the spirit of that change in rule coming from the individuals who made that change? What do you think ultimately their desired outcome was and is for partial changes of ownership?
I speculate on that and I have my own opinions, right? It's almost what I just said. I think that the spirit of that rule change was to allow more people to have access to exchange ownership from one generation to the next. We talk a lot about and we hear a lot about, the old generation that's retiring or moving on, and there needs to be this other generation that comes up and takes the reins. I see those partial changes of ownership as an avenue to do that. So an avenue to let small businesses continue or small businesses expand that previously couldn't have happened. And I think that's what they were trying to get at. What they weren't necessarily trying to get at, and again, complete speculation here, is the situation where people are trying to take advantage of those rules and, for investment purposes or figuring out, ways to get too creative with the structure. I'm not sure that they anticipated that. I don't know. Time will tell. And my guess is that in the next round of the SOP or procedural notices, they will clarify what that intent was and maybe clarify some of the rules surrounding it. But they've opened up that floodgate, and I don't think it's going away anytime soon. And it's ultimately helping that next generation of entrepreneurs really get into the driver's seat for what the next 10, 20, 30 years will look like for that small business.
Got it. I don't know if this was in the minds of the individuals who changed this rule or created this new rule for partial change of ownership, but one of the positives and benefits that I see regularly as individuals call me, and I'm working on several of these now, are what I call key employee acquisitions. Let me paint the picture. Key employee has been working at the business for several years. Maybe they're a manager, general manager, and the sellers come to him or her one day and say, "Hey, we're ready to sell you the business." Then the next thing they do is they Google SBA loans. They call me. I get this all the time. "Hey, Ryan, I work for X business. I'm the general manager. The sellers have given me the opportunity to buy the business." And I say, "Great, let me collect the loan package." I collect the loan package. I obtain their personal financial statement, and I look at the liquidity. My eyes go straight to how much cash do they have, and they have like $5,000 or less. They have credit card debt. They have a large mortgage here in California, especially. And what I have to do is get on the phone with them and say, "I'm sorry, I don't think you're ready." And my thought, my opinion is, and again, I don't know if this was in the minds of those individuals who fostered this rule to where it is today, but I think the partial change of ownership is especially positive for those individuals who are key employees to let the sellers stay on for a period of time as owners, make it easier for that key employee to qualify because according to the rule, there necessarily isn't an equity injection requirement. And then maybe the lender feels more secure because they have someone who's been running the business, but their weakness from a personal perspective is that they don't have that backstop, that liquidity that lenders like to see. And then with the sellers staying on as partial owners, they're able to keep themselves engaged in the business. What do you think about that thought?
No, I think that's really interesting, and that's a fair point, and I think that's a possibility. One thing that spins off from that is the situation where perhaps they needed the seller to stay on for licensing. Okay, like you said, qualified, and it made me think of that. So before the seller had to get out in 12 months. Well, maybe seller is key to the business because the seller holds a very specific license that allows the business to operate. The partial change of ownership allows that person to stay on to qualify the business. My only additional thought there is if that is the case and the seller truly is qualifying the business, and let's take the example of 5%, right? 5% pursuant to the SOP, if that is the post closing ownership, the seller does not have to personally guarantee the loan. Now, change the fact scenario a little bit 5% owner, but has some very specific, rare, hard to get license. Not required, but the lender's going to make that 5% owner a guarantor because at that point, that person is so key to the business that the lender uses their discretion there, which it is permitted under the SOP to say, hey, we have to get some leverage on you to keep you in this business because if you leave 5% owner, we're really in a bad spot. So it's important to remember that I saw a lot of people talking about, oh, the seller is never going to have to guarantee the loan. That's not true. And I've seen that a lot where the seller may not have that 20% threshold, but the seller is so key that that is an additional guarantor on the loan to keep it the interest there.
Got it. Lenders are still making prudent lending decisions, and they are told by the new SOP, do what you do. And so they have to adhere to that very specific language in the SOP.
Yeah. But to your buyers, though, that's kind of a good thing too, because if they're requiring that 5% owner to stay on, they're doing it because they say, look, buyer, I'm not saying that you're naive, but 3 months from now, what if that seller goes away? What if something happens and you're no longer able to operate? Well, now you're sitting on $4.5 million of debt that you owe every single month in monthly installments. You now can't make your monthly payments. You're now into default. A lender doesn't want a borrower to be in default. I think that's what they always have to remember is the lender is not the enemy. The lender can be your very best friend in the transaction, and they do have your best interests at heart. The only issue is where you get a lender who may have your best interests at heart, but doesn't exactly know what they're doing, whether because they don't have counsel or because they're newer to the SBA program and just aren't really inundated in the world of SBA itself.
Yeah, I share that from time to time with buyers or borrowers. Hey, banks are in the business of risk assessment. They just give loans. That's really secondary to what they do. Every single day, they're assessing risk for their bank, for their shareholders. And that's something that a borrower can take to heart. And if they take the time to think about it, really assess what is the bank saying to me? And like you just said, the bank can actually be your friend and they're going to give you advice based on their expert risk assessment experience. The next thing I want to talk to you about is the forgivable seller note. And what I see in a transaction and where this comes up often is where there's what I call tension in the deal. Like you said, not all deals are the same. In fact, they're all different. And what I see a lot of times is tension in the deal. And here's the specific tension: the seller wants to maximize the value of their business. However, what they've done is they've really stretched that debt service coverage ratio. And so that's the tension. They want max dollars for their business. However, the cash flow doesn't necessarily meet or merit from a debt service coverage ratio. And now we introduce the forgivable seller note. Can you talk to us about what a buyer should know when or if they agree to a forgivable seller note? I've also seen it called or referred to as a contingent seller note.
Mhm. Yeah. So what they need to know is that just like everything else we've talked about is a relatively new permissible aspect of some SBA deals. So the risk assessment of some lenders is they don't like to see them. Some of them will accept them under certain circumstances. And the certain circumstances is really important because I do see transactions where there is a forgivable seller note where it's fine. The way that it's set up is good. It benefits the buyer, it benefits the borrower, and it's eligible for the lender. That is going to be a circumstance where everything aligns, like with the valuation, it pencils out from a credit underwriting perspective. And most importantly, from my end, that seller note was not used as equity injection. Okay. Because when you tie something to equity injection, that decrease in the amount of the seller note can throw everything else out of whack because there are specific requirements for injection in any sort of transaction. And if you introduce a decrease, that can have an impact on everything else. So the ones where I see that there are issues is they have a, let's say, a $500,000 seller note, and it's a decreasing or forgivable contingent, whatever you want to call it, seller note that's being used as equity. That's not going to be a situation where that works. And the SBA, the lender, they're not going to approve that. Where it does work is where the seller note is more, leverage between the parties, or as you say, kind of a bridge to gap something when it's not being considered the equity injection. And I will see transactions sometimes where they'll have two different seller notes. They'll have one seller note that complies with the full standby periods and requirements, and it is being used as injection, no forgivable component. Then there's a separate seller note that is not being used for injection that includes that forgivable provision or certain terms that credit has deemed acceptable. At that point, you have injection, and then you have the forgivable mechanism that satisfies the party's needs. That's usually where I see it most often.
Got it. Got it. Well, I really appreciate you sharing that. And then one last question in regard to something again that's new. I've heard different lenders give different opinions on whether or not they like this new rule and or will even offer this option to their borrowers. And that is the rule, quote unquote. And maybe you can explain to us how this came about, but where a borrower, let's say a borrower owns a gas station and they have an SBA loan on the gas station, let's just say $5 million. dollars. And then they pivot and buy a school. And let's say they're qualified for both of those for some reason. According to what's been shared, those individuals now, even though they've maxed out their $5 million, dollars, can use other dollars from the SBA because of the difference in NACIS code to obtain another one, two, three, up to $5 million dollars for that particular NACIS code. Can you really dive deep into this new rule, the specifics of the rule, and how this is being implemented by SBA lenders?
That's one of those newer rules that is still pretty gray. And so I'm seeing drastically different interpretations of that rule from lenders. And maybe that's what you meant. Some will look at it and say, yes, that's fine. I've heard it, I've seen it in writing from some that say, hey, that's fine. But others will say, absolutely not. That is not what the rule was meant to do. In those situations, what I'm seeing people look to in the SOP is less that and more of the expansion opportunities, right? With the NAICS code that you mentioned before, those types of expansion loans, if they're following the rules of the SOP to a T, that's the option that they end up taking and using it under an expansion rule, using the equity requirements or lack thereof of the expansion program, and considering that as their option more than just the doubling up and having more debt than what the SBA currently allows, which is that 5 million.
Mhm. Got it. Yeah, thank you for sharing that. And what I'd like to close with, because we talked about what a bad buy side attorney looks like. Let's share some positivity as we leave this podcast for the audience. So when they are choosing their buy side legal counsel, they're making sure they're choosing counsel who understands the SBA, who will be there to advise and represent them, but who ultimately will be on their team to help them get the transaction to the finish line and cooperate with you all the way through the process.
I love it. I love the ending on a positive note piece. The negative side, we did talk about inexperienced or overly experienced. Right in the middle, it's almost like what is that? Goldilocks and the Three Bears, right? The just right is when you have either a person at a firm, maybe a boutique shop, somebody who has done a fair amount of M&A transactions in the lower to middle markets. Okay, that really is the key because those transactions are so different from other types of transactions. So M&A experience, one, and then two, having experience with the SBA program. So somebody who has represented a buyer who has received an SBA loan to buy another type of business. That is usually a major green flag for me. But even if they haven't been through the SBA program before and they're just familiar with mergers and acquisitions, if they're the type of attorney who understands the importance of just communicating and negotiating and figuring out how to get to the finish line, those are the ones that I work best with. Because when we get a transaction, the first thing I'm asking that lender is, okay, who is the deal team? And if they say Ryan Smith is buy side attorney, I know you're not a lawyer, right? If Ryan Smith is buy side attorney, the very first thing I'm doing is I'm sending an email to Ryan saying, hey, I'm Scott. I work at Lewis Kappes. We have one of the largest closing teams in the country. We have done this before. Here's what I like the process to look like. Let's hop on a call. Brief, to the point. Then we get on a call and we sketch out the entire closing process. If an attorney is willing to do that with lenders counsel, I know that transaction, despite there might be bumps, it's going to get to the finish line, God willing. It's going to get to the finish line and it's going to be a much more enjoyable, smooth process, not only for my side, not only for my client, but for the borrower, because the attorney is doing what an attorney does. They're picking up the phone, they're communicating with the other side and really sketching that path towards whatever it is that's the target for that specific client.
Awesome. Scott, I really appreciate your time. Thank you for joining us on the podcast. We covered a lot of different topics. We dove deep, and I think that the audience will really appreciate what you've shared with us, and have a great rest of your day.
You too. Thank you so much.
Thank you.